Albert Keyack. Ele é o cônsul para propriedade intelectual para a América Latina do Consulado dos Estados Unidos. Por favor, Albert.
Obrigado. Bom dia a todos. Good morning. Good. Antonio asked me if I would talk a little bit about intellectual property and angel investing and all kinds of investing actually in the U.S. and how the system works. I was a intellectual property lawyer for about 25 years in the U.S. and last year came down here to Rio de Janeiro, and I'm the consul for the U.S. government for intellectual property for South America. So while I'm here, I do different things than I did as a lawyer, obviously, and probably my presentation is more about the things I used to do as a lawyer. Here in Brazil in particular, we try to have good relations with the U.S. Patent Office, the Brazilian Patent Office, and obviously all the other countries in South America. We work a lot with innovation and innovative companies, and it's important both to the U.S. system, ecosystem, if you will, and also to Brazil to see these kinds of things go forward, to see software companies start up, to see biotech companies start up. Last year, the U.S. rewrote its intellectual property law, its patent law, last September to provide sort of a different structure for how patents are generated in the United States, how patents are applied for. I have some things to remind me, but I really don't have slides because I didn't think this would be the kind of talk that we really needed to have slides for. For me, I started out as a patent lawyer where a client comes in and says, get me a patent, and you say, great, okay, because you're going to pay a fee for me to do that work. And when you're very young, you don't think it through. You don't think about, well, what's the client, why are they there, and where did they come from, and where did they get the money to pay you? And certainly some people get patents, large companies get patents, individual people get patents that are just inventors. And you quickly differentiate between an inventor and an entrepreneur. An inventor wants to simply get a patent and hopes the world will just come to him or her, and or a company will come and make them wealthy overnight like a lottery ticket. Or an entrepreneur has a vision, has a passion, and wants to build a company. And what we see over the years is a lot of entrepreneurs either skip over the intellectual property part or they come to it late, again, at the investor's stage, because an investor will say to them, well, what's your intellectual property? And they'll say, what's that? Or, yeah, I'm supposed to do that. That's what I'm going to use the money for that you give me to invest. And the investor says, well, you should have already done that before. So over the period of, say, the last 20 years, you've seen this sort of dynamic change of where intellectual property fits into the investment community, into the angel community, into the VC community, into the mergers and acquisitions, M&A picture. And it's changed a lot. For me, I've seen it where it was really just a line item on a list. People would check a box and say, yeah, sure, you have intellectual property, to where people really actually analyze the patents. They actually look at the markets that are controlled by trademarks. They actually look at the copyrights and the ownership of written materials and content and code as well. Code can be both patented in the U.S. and it can be and it is protected by copyright. I guess I usually start just because a lot of people ask these questions. Just what are the sort of basics of intellectual property for a tech company? And there are really 4 kinds of intellectual property: patents, trademarks, copyrights, and trade secrets, or kind of like everything else, competitive information. People give it different names, but it's things that don't fit into those first 3 categories. And copyrights are the easiest one to talk about. If you write something, or if it's artistic or music, it's registered. In other words, the minute you create it, you own a copyright in that thing, and then you can register it with the government. And this is true in most countries, but in particular, I'm usually talking about the United States. you simply mail it in, literally, to the Copyright Office, and they register it. They don't care what it is. They don't, ask you any questions. Well, occasionally there'll be some missing information or something, but they basically just register it, put a stamp on it. So gaining copyright rights is very easy, and copyright can be valuable, but for many tech companies, the copyright really isn't what protects their interests. Maybe in gaming, in gaming, there'll be some value to copyright, but the copyright-driven industries are mainly the entertainment industries. So movies, music are the primary drivers of copyright law, copyright value, and so it exists and it's useful and important. But for whether it's a software company, an internet-type development company, or a pharmaceutical biotech company, the copyright part of it isn't really that big of a portion of their value. The next form of intellectual property is trademarks, and trademarks are not quite as easy to get as copyrights. The trademark is your brand, and it can be hugely important. It's obviously most important in consumer goods, but it can be important in a lot of contexts, particularly in the naming rights and in the if there's something that sounds like another name and there's confusion. So it's part of the process of creating a company and creating a product that you'll have to do a naming exercise. You'll have to come up with several names. Usually you go to a lawyer who will hire a service who finds out if any of those names are in use somewhere else. And then we'll also do a legal analysis and tell you, can you actually register this trademark? Because you can just put a name on a company or a name on a product and just walk out there and start using it. That's fine. You may or may not get sued or may not get stopped from using it because somebody else that you never heard of might have that word or phrase already trademarked, and they might not even be a competitor of yours. There might be a microphone company that has a name, and there's a camera company that has a name for one of their products, and they're the same, and they say, well, we don't compete with each other, but the trademark law kind of doesn't care. Like there are similar or identical trademarks in non-competing goods, but it's very hard to do that. A lot of those are for historical reasons, that there's actually a car called Cadillac and a dog food called Cadillac. That's because there's a town named Cadillac, Michigan, and both companies were founded there, so they let that one kind of go through. But in general, you have to do what's called clearance. And it's not really that expensive and not really that difficult. In the US, you can register a trademark for something on the order of $1,000, and it maybe takes 6 months. In other countries, it takes longer, it might cost more. But it's a question you'll be asked. It's like, well, this is a great name, we love this name. Did you do a trademark clearance on it? And if you didn't, the investors know, A, you're gonna have to spend some of their money for lawyers to do the trademark clearance, and B, now there's a risk. Maybe you have to change the company name, and maybe it's a great name, or maybe it's already a website that's attracting traffic. Maybe it's already a product that people have an awareness of. So that's a big sort of cliff if that happens to a young company. And it's a shame, and usually it's avoidable. Usually people have enough information around them, their advisors, their friends, their colleagues, that they're kind of aware that the trademark is going to be a part of their intellectual property. The sort of last and most difficult part of intellectual property is patents. In the US, there are 3 kinds of patents, but it's sort of like 80, 19, and 1%. The bulk of the patents are what are called utility patents, and therefore an invention. And an invention can be anything. It can be a new molecule, it can actually be a genetically modified life form, it can be an idea of a business, of how to make a business work. It can be a method of doing something, a method of executing software, of executing something that's either in the web or in a device, programming, a programmatic kind of invention. So all these things are available as inventions. The sort of question becomes, how much of an invention is it? Is it a big differentiating kind of invention, or is it a minor incremental improvement? What's interesting is many times the incremental improvements are where there's value. There's value both for in terms of pricing, and there's value in terms of your ability to gain market share. And sometimes people say, well, their patents are a bunch of junky little patents. It's like, yeah, but everybody copies those little tiny improvements, so that's where they have the value, because that they didn't maybe invent the thing itself, the new idea, but they have all the right little improvements around it. But to go back to just the general concepts of gaining intellectual property, patents are also fairly expensive relative to other forms of intellectual property, and very time consuming. It's very time consuming for the company to write a patent and very expensive to pay the lawyer. And it's a long process after that of what's called patent examination. After a few years, 3 to 5 years in the US, longer than that in other countries, a patent examiner takes up your file and says, let me read this. And it's a person who has a lot of knowledge in your specific area of technology. Again, if it's a biotech invention, the person reading it will be a biochemist with years and years of experience in biochemistry patents. So it's not a random sort of, government person they hired. They're a very, very well trained and highly specialized person, but they will look at your patent application and then do a lot of research and try to figure out, did anyone else ever invent anything like this before? And that process will determine whether or not you get a patent up or down. But also what they will do is when you write a patent, you basically ask the government to give you a limited monopoly. You say, I want to have this little sector of the world to be all my own. Well, in the patent application, there's a written description of what you think is your invention, and then there's a part called the claims. And the claims are what you think your invention is. If the claims are too broad, if they would cover existing products and therefore affect the markets for those existing products, your patent is rejected. So what patent lawyers do and how they why they earn their money, or where they really earn their money, is the negotiation with the patent office over exactly how to write a claim so that it's patentable but still covers something that's worthwhile for the company. In other words, you can get a patent on something that is so refined and discreet that it's almost worthless. It's a black chair that's made on Tuesdays. It's like it doesn't cover all black chairs. It just covers black chairs made on Tuesdays. It's like the patent office would let you do that because they'd look at the words and say, well, sure, nobody ever wanted a patent for chairs made on Tuesday before. Go ahead, have fun. But there are obviously more serious examples of this kind of stuff. But you go back and forth with the patent office, and that's what takes a long time. And what I always remember is the person who taught me a lot, my mentor, said the greatest patent claim of all time was a method for making aluminum using electricity. And that's all it said. And that was the patent that founded the Alcoa Corporation in the United States in the 1800s. But rather than write up a whole electrolysis and there's an anode and a cathode and the aluminum comes out of the bauxite, and the patent lawyer just sat there and said, no one ever has separated out aluminum from ore using electricity before. They smelted it with heat and chemical processes. So the patent lawyer wrote up a patent that just said a method of making aluminum, okay, we understand what you're going to do, using electricity. The patent office said, no one else has ever done that before, patent granted. Now, no matter what the voltage was, no matter how big the tanks were, no matter the alloy content, it didn't matter. Are you making aluminum? Yeah. Are you using electricity? Yeah. You have to pay Alcoa a royalty, or Alcoa can put you out of business, or Alcoa can keep other people out of the business. So that's probably the closest thing outside of a pharmaceutical where the patent truly was a monopoly. But even then, you could still make aluminum, you just couldn't use electricity as the process to extract it from the ore. So that's kind of and these days it's probably more and more rare to have a patent like that you truly invent something that no one's ever done before and you get such a broad patent. But most patent lawyers still try. They try to ask for more from the government than from the patent office than they really need, and it's like any negotiation, and you cut it back and you come to a balance and then you get your patent. So you have the copyrights, the trademarks, the patents. In general, for a young company, the patent part of it is difficult too, because people will say, well, what should we patent? Should we patent, you know, the front end, the back end? Should we? There's all these subcomponents of their product or their technology, and sometimes it's kind of evident, again, to a good patent lawyer that's has a lot of clients. You see a lot of different things, and you kind of get a sense. You say, well, in general, what you want to patent are these kind of areas here, and they will help you determine it, and also, in some ways, the market will help you determine what should be patented. It's difficult sometimes to just say, well, you know, I want to patent on that television. Usually when I talk, for whatever reason, there's a water bottle or a soda can, and there are hundreds of patents in one water bottle. The plastic, the molding technology, the shape of all those ribs on the side of a water bottle. There's a different kind of plastic on the lid. Just something as simple as a water bottle has not one patent, not a couple of patents, hundreds of patents. So it's a little surprising to people sometimes, because they're like, I need a patent on my, you know, product that I'm going to bring out because I was told I need a patent. It's like, well, you're either going to have to write 5 or 6 patents, or decide, if you have a budget, which is the most important features and which we're going to kind of go for first. So it can be difficult, but that doesn't mean you shouldn't get started and do it. And even if somebody says, well, you're going to need a whole portfolio of patents, you can't not do any. You have to somehow, you know, collectively through a combination of the management and the lawyer's advice, and if you have investors, the investor's advice, figure out where you should protect, or what's the most valuable thing to protect. And then, as I said, there's kind of a fourth part of intellectual property, usually called trade secrets. Here, Brazil actually is very similar to the United States. They protect trade secrets and know-how. The difficulty with trade secrets is, and again, a lot of entrepreneurs say, well, why don't I just make everything a trade secret? I'll have all my employees sign these secrecy agreements, and you know, you can't figure out how I make my product by looking at it. That's not always true, but hypothetically, if it's a product like that, this is what the entrepreneurs will say, because trade secrets really don't cost anything. There's the management cost of maintaining a trade secret, but that's the problem with trade secrets. The good thing is they're very low cost and they last forever. The bad thing is, as soon as they're revealed, they're gone. I didn't mention this earlier, but copyrights have a term. It's the life of the author plus 75 years. It's a very long time. Trademarks can last forever as long as you keep using a brand. A lot of famous brands, you know, Coca-Cola is over 100 years old. Many beer brands are several hundred years old. The breweries have been in business that long. So trademarks can last forever. Patents have a definite, specific lifespan. From the day you file the patent, 20 years later, it expires and it's over. Trade secrets and know-how protection, or however you want to categorize it, it will last forever, but it only lasts as long as you keep the secret. And again, if you're 3 people in a little tiny startup, you say, oh, well, we'll just all keep this a secret. Yeah, you can do that. But as you start to hire people, you hire consultants, you get your product out in the market more, your company grows, which is what you hope you're going to happen. Or when you go to sell your company, you're going to sell it to a much bigger entity. Now it's getting really difficult to keep trade secrets. There are a lot of really good and valuable industrial trade secrets, particularly processes that aren't really appropriate to be patented, almost like cooking. Like there's little tricks people do sometimes in chemical processes, in plastics, and different industries that I've worked in. It's almost like a recipe. They'll say, well, the real trick for this is we add a little bit of something, you know, into the mix, and that makes the yield, the batch, you know, yield better. And those can be good trade secrets, but you really, really have to take huge, huge pains to keep them a secret. If somebody does kind of industrial espionage and reverse engineers your stuff, and as long as they don't break the law by breaking into your plant or something, if somebody figures out how you're making your product, that's too bad. You have no what lawyers call recourse. You have no action against them if they didn't do anything illegal. But you can, occasionally figure out what somebody's doing and reverse engineer it. So if your only protection is trade secrets, and you lose the trade secret, you have nothing. It's gone. So that it's a difficult balance. In general, trade secrets are of limited use, especially for startup companies. The most valuable trade secret a startup company would have would often be some kind of either customer lists or vendor lists that you've already maybe introduced your product, you already have a connection to them. That's basically not as much a trade secret as proprietary information, and your employees would have access to that and then not be able to take it with them to start up another startup company down the street. I guess you look at intellectual property. What probably the only thing I wish I had a slide for was people talk about a virtuous cycle with sort of the way the tech world works. That in order to discover something, you need to have some kind of research done. And research usually doesn't get done for free or fall out of the sky. It takes capital. But if you have to start somewhere, so you start and you do some research. The research will typically develop intellectual property. And in university contexts, it also develops papers that are published, but those papers are usually connected to intellectual property in some way, particularly patents. So the research generates intellectual property. The intellectual property, at the same time that's going on, you generate some kind of a product, which generates an ability to raise capital, which then, as you have a successful product, then you can exit, but then the exit provides the capital for the next round of research and innovation. But in this sort of circle of research and innovation and a product is the intellectual property carrying through, which gives you some of the ability then to transfer value to somebody else. So that's kind of how we typically explain like where the IP fits in this sort of scheme. Like does it have to come in the very beginning? Not really. You have to do some research and have your ideas, which is usually an entrepreneur's kind of already past that. So the IP has to come in fairly early, because as you get into the product development and capital raising stages, if you don't already have IP in place, sometimes it's too late and you can't go back and get it. You've kind of lost it. You've lost your opportunity to get the IP. So I guess, does anybody have any questions? Because I'll talk a little bit about valuation, but sure.
Yeah, I have a question regarding the secret technology. You spoke about once your claims are published, it became public domain. Well, so I believe that the secret stuff, particularly military technology, they don't go for patents. Otherwise, their secrets are going to be revealed.
Right. Well, I was talking about there's two different ideas there. When you file a patent application, it stays secret, so to speak. It stays inside the patent office for a period of time, and then after 18 months, it's published. And because patent offices around the world are so slow, a lot of times the patent application is published before the patent issues. So a lot of people say, well, my competitors can read my published patent applications and they'll know what I'm up to. And then I usually say, well, remember, depending on your industry and everything, that patent application, the text, is 18 months old, and it probably took you a couple months, if not longer, to get to the patent lawyer to get some drafts and go back and forth and write it. So the ideas that are in a patent application are probably around 2 years old. So unless you're in a really, really static industry, 2-year-old information is usually not earth-shakingly valuable. Like, oh, like I saw in a news article once, somebody was reading Apple's published patent applications, trying to figure out, you know, what the iPhone 7 was going to look like or whatever. And it's like, I don't think Apple even knows that yet. I think they move faster than 2-year spans. I mean, certain R&D takes a long time to develop, but the early stage R&D patents don't reveal often very much because, again, they're written in such a narrow way about the basic technology. But what I was talking about when I talked about secrets was the classic example is the formula for Coca-Cola. Supposedly, only 2 or 3 people in the company know the exact true formula, and they keep it in a piece of paper in a safe, and you know, they don't tell different people in different divisions that make parts of the syrup that they finally mix together what's in it. So they have all this system in place that keeps their secret a trade secret. So that's when I was talking about secrets as a fourth kind of intellectual property. It's a true trade secret where you have proprietary information that you keep within just a few people, and it's important and valuable to your company. And the two kinds are technical trade secrets about how to do something, how to make something, how to tweak a device, or how to mix up a certain kind of chemical. And then another form of trade secrets is proprietary customer lists, which again, that sounds weird, but in certain industries, who the customers are and who the buyers are, that's very valuable. And if you can get that instantly, not develop it up over years, it's a valuable trade secret, and it's an asset of your company, or an asset of your sales division at least. I guess before I talk about valuation, another area where a startup company will have problems, and especially there are some odd things about U.S. law in terms of ownership. You know, we talked about patents, trademarks, copyrights, trade secrets. It's never 100% intuitive as to who owns what, because people will say, well, we were all working together, so the company owns everything. It's like, well, did you all execute assignment documents to assign to the company? And again, in due diligence, which we could talk about later, but you know, people say, well, where's all your assignments? It's like, oh, well, we didn't do those yet. Well, then sometimes the thing is owned by the person who invents it. Sometimes it's owned by the person who paid the person to invent it, and it varies. And in fact, in the U.S., it varies from state to state to state. Some of the things aren't controlled by national law. So that's another area where, in my prior practice, not my role in the government now, when companies would come in and say, hey, we want to buy this company, can you check out their intellectual property? We would certainly look at the substance of the patents. What does the patent cover? We'd see if their trademark was registered. But then we'd say, okay, where's all your ownership documents? And sometimes some fairly big companies that had gotten well past angel stage, had gotten into venture capital, had gotten into the market, had revenue, they said, oh yeah, we were going to do that, but you know, the lawyer we had, she had a baby, and she took 6 months off, and she had taxes due, and you got to do your taxes, you go to jail. So they just never did their intellectual property assignments or their employee agreements. And it's like, guys, like, you know, these two coders over here own your code, and you know, the inventor of the patents never assigned, so he owns like a 50% share of the stake of the patent with his co-inventor, and if they quit tomorrow, you're going to have to sue them, you know, under some premise of the law that they orally, verbally promised you to assign the patents. So suddenly, like a fairly tight little box of intellectual property is a big mess because there's no ownership, because the ownership is unclear. So with startup companies that I've done in the U.S., they have the NVCA, the National Venture Capital Association. They do a lot of different workshops like this, and they do what they call boot camps. But this is often what we'll talk about more than what's a patent, what's a trademark. We'll talk about how you get ownership and how to make sure you have ownership. A lot of young companies hire consultants. Sometimes consultants have a clause buried in their consulting contract that says, oh, by the way, I own all the intellectual property. You're just paying me this exorbitant fee to be your consultant. If I invent something while I'm working for you, you have to buy it from me. or negotiate with me. And usually, if you say, oh, okay, we'll just get a different consultant and strike it out, then they'll negotiate and they'll take that clause out. But a lot of times companies, they don't even read that far, or they just sort of say, yeah, what could the consultant possibly invent? And then guess what? The consultant's the guy who said, we should really, do this. Like, we should put the button down here, or we should add this feature to the website, or hey, did you ever try making, this product using this process? Suddenly, the consultant, who you might have paid a lot of money to begin with, now owns the intellectual property because it wasn't taken care of before you hired them. And that's often kind of a shock to some startup companies. They're like, what? We needed this guy, but all he did was design the casing for our device. It's like, yeah, but he owns that design. So you have to either license it from him or buy it from him or give him shares in your company. And it's not like they're evil people, but they're just taking best advantage. Like, they had a good lawyer when they wrote up their standard consulting contract. So it's like you have to equally be aware and be savvy and sort of, change the parameters of the consulting agreement to have ownership. Because what I wanted to talk about next a little bit was just some of the general ideas of valuation. And before you get to valuation, before somebody will put a value on your company, they'll do the due diligence, and the ownership is part of it. So I wanted to get that in there. Yes?
Albert, what about copyright and patent? How they interact?
They primarily interact. Copyright, like the English words would suggest, it's to prevent people from making a copy. And it was originally intended for written works, artistic works, and music, so that the authors and composers could control the images and the music that they created. As time progressed in the US, new technologies keep coming out. You have phonographs and films and radio and television. So they kind of keep adjusting the trademark law the copyright law for all those things. Then suddenly in the 1970s or so, there was enough software in the world that people said, well, wait a minute, how do you protect intellectual property in software? And most people here are too young to remember, but software, was on cardboard cards with holes punched in them, and code was written on this paper with alternating shades of green bars. And people said, well, software code is written. Whether it's machine code or whether it's high-level code, it's written. So as a written work, we're just going to protect it as copyright. That was kind of a lazy way to do it, but that seemed like the best ideas at the time, because at the time, the patent office said, you can't patent what goes on inside a machine. Like, that's not a process. That's just code being executed. It's not really what we consider a patentable invention. So you had the patent office saying you can't patent code. And the fallback then is like, well, we'll just protect it by copyright. But copyright for computer code is a fairly weak form of protection if you want to sue somebody, if you want to get an injunction, if you want to get damages. Anybody who's written code knows you can just move some subroutines around, or you can just change the way some formulas are written. You can do some math differently, and it looks different. And that's the copyright test. Is something a copy? You have to put them sort of side by side and go, oh, are they a copy? Copyright doesn't protect a theory. You don't protect the plot of a movie. You protect line for line for line the dialogue in a movie. You don't protect the ideas in it. You don't protect a broader concept. So that suddenly was what became worrisome in the software industry, because they had code that could easily be rewritten to not infringe the copyrights, but you were stealing their ideas. So you had companies like the video game arcade people at the time, Atari, Konami, I think, they brought big lawsuits to protect their ideas in the copyright, and they tried really hard, and the lawyers worked really hard and tried to force copyright law to cover more like a broad idea. And it really kind of didn't work, because copyright was never intended for that structurally, like the language in the statute. So finally, another push came where people would sue the US Patent Office and say, you have to give me a patent because this is an invention. It fits into our, our constitutional scheme in the US of what's supposed to be protected. So in the end, the people pushing for the patent law to be expanded kind of won the day, and that did end up to be the sort of better methodology to protect software inventions. And there's a lot of criticism of that because every country now protects software to some extent by patent, but it varies by degree. But in general, as I said earlier, you can protect almost any form of software, any form of process with a patent in the US. And now, really no one worries too much about the copyright aspects of code. And copyright has kind of drifted back to protecting movies and music and artistic works and novels and any kind of written work.
For software is not being used.
Right. I mean, you can still, people do register every day software code because it does give you another weapon in your arsenal if you have to sue a competitor. Because some competitors don't care. They'll take your code, duplicate it, put it on their machine, basically counterfeit your code. And that's a whole different sort of area of the law and a whole different set of ideas, how you attack someone who copies your ideas. That would be true. You don't lose your property, you just can't stop. It's just like if somebody much, much bigger than you wants to take your wallet. Even if you fight, if you don't have enough force to stop them, they'll get it. You're right, if somebody, whether they're bigger than you or not, if somebody infringes your intellectual property, if they copy your product and it's patented and it has a trademark and there's copyright aspects to it, if you can't afford a lawyer, in most countries, in some countries, in China, I think in Germany, there are cases where it's almost like a prosecution of a criminal. That they will have a public prosecutor who will sue the company, but in those countries where they have public prosecution of intellectual property crimes, they only get an injunction. And occasionally they put people in jail, but really the main thing they do is they stop the person from being on the market. They get a court order that says you're not allowed to sell that product anymore, which is a huge thing. It's a very big thing, but you also don't get any monetary damages. So, but you're right, that's a big downside of the legal system, that if you don't have the money for lawyers to enforce your rights, people will can walk all over your rights. And unless you have a situation where a public prosecutor, where there would be, in the US you'd have to have a criminal activity for it to be prosecuted by the government. Otherwise it's up to a private party, a company or a person, to hire a lawyer and sue the infringer. Actually, and that's a really good question, and I probably should have had that point brought out earlier. Every country with a market has intellectual property laws, and every country issues patents and registers trademarks and copyrights. They all are territorial within that country. So there really is no such thing as a worldwide patent or a worldwide trademark. What there are treaties and agreements between countries. And a lot of people say to me, they'll say, oh, I have a patent in the US and I want to sue this Brazilian company. And I said, well, go bring the lawsuit in New Jersey. And they say, no, it's a Brazilian company. They're copying my product. And I'm like, well, do you have a Brazilian patent? They say, no. I said, well, you can't sue them because they're here in Brazil. They said if they bring the product into the US, go ahead. Sue them in the US at the port in Florida where they unload the ships. That's where you bring the lawsuit. Because a US patent only covers the territory of the US, and that's it. So you can't stop a Chinese company from shipping stuff. You couldn't stop a Chinese company from shipping fake iPads into Brazil. Apple couldn't, unless Apple has Brazilian trademarks and Brazilian patents. And I think they do when they can. So that's why you don't see big companies have enough money, again, to get patents and trademarks all over the world. But what happens with a patent is you file a patent in your home country, you file a patent here in Brazil at INPI, at ANP, And that patent, as we said earlier, goes into a process and it sits in the patent office. 1 year later, you then file in all other countries where you have an interest in having a patent. And that, again, is for a small startup company, that's an expensive proposition and a very difficult decision to make. Because, again, they say, oh, yeah, just file everywhere, worldwide. We're going to be in Japan, we're going to be in Europe, we're going to be selling this stuff everywhere. And you say, okay, it's like maybe 50 grand the first year, and then it goes up and up and up. And it's not fees for lawyers, it's fees to governments all around the world for filing fees for what are called annuities. It's very expensive, especially in Europe. It's like $5,000 a year per country, just to keep your application in a box, not even get examined, not even have a patent. So then companies are like, whoa, $50,000, we could hire another engineer for that much. And it's like, well, now you have to decide, where are your biggest markets, where would you likely to have a partner, where would you likely to have an ability to exit, that the company would be based in that country and be very interested in having patents in that country. So it's a very difficult management decision. And in bigger companies, there's whole teams of people, lawyers and business people, who monitor their patent portfolio and keep it, within budget, because even the biggest companies can't expansively just patent everything everywhere. It gets just too expensive. Because when you combine the government fees then with the eventual lawyer fees, it's millions and millions and millions of dollars. So there's agreements. You file a patent in your home country. A year later, you can file what's called PCT, Patent Cooperation Treaty. It's a sort of one shot, one form, and you check off all the boxes of all the countries around the world that you would like to get a patent someday. But then from there, what that piece of paper does, it goes to the different countries, and then about 18 months later, all those countries come back to you and say, we received your PCT application. If you're really interested in the patent in Japan, now you have to file a Japanese application. The PCT thing was just kind of like a placeholder, because again, now you've been in business maybe 30 months, maybe more than that you've either started to succeed or you're clearly not going to make it. So, and for big companies, it's the same way. They look at it as a project. They say, well, this project that we started a few years ago, we're going to kill that. We're not going to bring that out. That's not going to work. The technology doesn't work. So often, the PCT system is good because it gives you some breathing room. It still costs money, but compared to before the Patent Cooperation Treaty, you would have to go run around and have your home country lawyer hire lawyers in 47 different countries to file your application only a year after you did the first application. That's a pretty short time. Even in our modern, high-tech, high-speed world, a year is still a pretty short time in product development cycles. But you can imagine, 50, 75, 100 years ago, it took a year just to send a few letters back and forth, between countries. They did telegrams and stuff too, which were faster. But you get the idea that people said, wait a minute, we need a system where you can have some breathing room and not have to file applications all over the world. So that's why a lot of people think of like a world patent or something, because they're maybe familiar with the PCT. But the PCT is just like a route. It's like a system that allows you to file patent applications all over the world. But each and every country issues its own patents based on its own laws, its own standards, on its own pace. Some are faster than others, some are slower than others. And the same with trademarks. You can file a trademark in each country, and I had this situation with many clients. They would get their trademark in the US, and they'd say, gee, we better get it in a few more countries. You file it. France, would say, yes, no problem. Italy, no way, you're not getting a trademark here. That word is already trademarked by an Italian company, blah, 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 blah. It's amazing sometimes, but countries that are pretty close to each other will say, one will say yes and one will say no. But that's a kind of anecdotal, like each case takes on its own life. There are agreements within the trademark community as well, the trademark offices around the world. One's called the Madrid Protocol. There's some other ones that allow trademarks to be sort of more easily filed between countries. But again, each country has its own sovereign laws, its own ability to determine who gets a trademark. Within the area of trademarks, this probably would almost never come up in a startup, But within the area of trademarks, there's something called geographic indications. And what that means is, if you sell cheese and you call it Parmesan, it better have been made in Parma, Italy. If you have champagne, it better come from a little region in France where champagne is made. You can't make sparkling white wine and just call it champagne. Even though it might taste like champagne, it usually doesn't, but you can't call it champagne. A lot of countries, Brazil stopped a Japanese company from selling a product called acai. If you're going to sell something that is called acai, it has to come from Brazil. You can't just like grow berries in Japan and then call it acai, because they convinced this sort of the people who monitor the geographic indications that acai was like champagne and Parma and cachaça. That's a GI. That's a GI as well.
Our brother in Germany.
Right. So, and it's a little confusing because geographic indicators are not trademarks. Not one company owns them, but any company that's making that product in that region kind of shares it. But they're almost like a quasi-national, like the country wants to protect its own citizens' businesses by protecting the geographical indication. So that's kind of, I think when you asked your question, you weren't asking about GIs, you were talking about geography in general, but you had me thinking about the around the world stuff, so I wanted to mention that. Because it seems like a lot of people, it's kind of a new thing in intellectual property too. People will say, geographic indications, and most people look at it and say, isn't that a trademark? And it is, but it's a trademark that's kind of shared collectively by all the people that make the product. Sure.
And regarding trademark, most of countries today, if you register locally a domain, internet domain, they give you priority over the trademark legal process.
Right, and vice versa. If you've had in the early days of the internet, there was the whole trademark squatting activity. People that had established trademarks, they never had a website for 1995 or 96 or whatever year it was that they got started. And they would go to register McDonald's.com and they'd say, somebody already owns that. And they'd say, well, that's our trademark. And if you're going to make it a website for anything related to food and hamburgers or restaurants, like you're infringing our rights. And that was another area of the law. The courts at first were like, whoa, wait a minute. That's not necessarily true. A domain name isn't really like goods, because trademarks protect goods and services. But then they decided it was a service. And I know lawyers who spent years doing nothing other than litigation, where somebody had a domain name and somebody had a trademark, and they each wanted it. You give me your trademark. No, you give me the domain name. So again, in the U.S. at least, what do? You hire lawyers, and they work it out, and the courts work it out. And sometimes you don't want the courts to work it out, because they don't often come. At times, they don't come to a decision that makes any sense at all. However, now there is a system called ICANN, I-C-A-N-N, that registers domain names, and they have a dispute resolution service. And as you said, it's very straightforward now. There's no more trademark squatting. There's no more domain name squatting. And if you come in with the right set of facts, and I've done this, ICANN charges a very reasonable fee. I don't remember what it is, but it's just a few $1,000s. It's nothing like a litigation cost. And you send in an affidavit, you send in the facts, the dates, print out of when you registered a domain, print out of when you filed the trademark, and they look at it and they just award the domain name to who deserves it, like who actually was using that word in commerce first. But it's on the one hand, some lawyers have to find something else to do now because their business of domain name disputes went away. But the good thing is for stakeholders, for people that file, people that register domain names, and people that want to make a business based on the internet, there isn't this crazy like, I have to pay a squatter because somebody got the name and bought it, for $10 a few years ago, and was stacking it up like some kind of a storage warehouse of names or whatever. That's kind of all gone out the window, and it's pretty, in my opinion, in my experience, it's pretty straightforward now that if you genuinely were using the word as a trademark, nobody can steal the domain name. And if you register the domain name in good faith and it's not infringing somebody's mark, they can't like steal it from you. I'm not sure. I don't think you have to use it commercially. I think what they tried to do is write some rules that people couldn't buy, you know, millions of domain names and just hoard them. But I've never really had to look at that question. The times I've looked at it, it's always been one-on-one, like a client said, somebody else is sitting on this domain name, we have to get it from them. And, you know, like I said, in whatever year, 1998, that was a big deal. And by the late 2000s, it's just trivial, really, honestly, as a lawyer thing. The Madrid Protocol allows a trademark applicant to file the same application around the world. So it's what they like to call harmonization, that you can not, as I said earlier about the patent stuff, you don't have to go and hire, on the first day you file your trademark application, you don't need to hire local lawyers. The trademark offices around the world will accept a Madrid Protocol application from another country and deposit it in their system. But again, once you come to the point of examining the trademark application and deciding who gets a trademark, it's still country by country by country. But the Madrid Protocol just allows for a little less burden on the applicant to get their trademark approved in more than one country. And there's a lot of technical stuff with how you categorize your trademark, what the search categories are, what the goods and services definitions are. The Madrid Protocol countries all agree to that, so that your lawyer, when he gives you advice in one country, the laws don't have to be completely consistent, but you have a good sense that you say, look, we're going to protect this trademark in this category of goods because it's cleared, nobody else is using it. And you know that when you go to another country, they're not going to say, oh, we don't do it that way. We have a completely different way of looking at trademarks. You know that between Madrid Protocol countries, there's a little bit of consistency in how they view trademarks, how they categorize them, how they search them, what's going to be allowed to be a trademark and what's not. So it's, but I don't want to imply that the countries have to have like the exact same statutes, written to the exact word for word. Each country still, like I said, my example of my client actually was a winery, and one of their wines was trademarked in France and not trademarked in Italy. Just Italy didn't like the name. They said that name's in Italian means something and somebody else is using it and all this stuff, and it was kind of like, no way. And yet all the other Western European countries let this company have trademarks on their and they were names of wines. They weren't geographical indications, and they weren't names that mean something in another language. They were, they were like, I forget what it was, like M red, M period RED. But Italy said you couldn't trademark that, and yet a lot of other countries did. So I don't know. And again, they're all Madrid Protocol countries. That's the earliest signatories to the Madrid Protocol. I guess you look at intellectual property and you say, well, this sounds pretty complicated. We have to hire a bunch of lawyers. Nobody likes lawyers. We don't like to pay lawyers. But you do it because your investors typically tell you should do it. And at a certain point, every company gets a valuation put on it. We heard the speaker earlier talking about how much money to ask for, and then when you ask for money, it's based on, usually it's then based on the valuation of your company. That correlates to how much stock you have to give the investor. And that's not what I'm here to talk about, but that's kind of why people put valuations on companies. Because if you ask for $500,000, does that mean you own 90% of the company or 1% of the company? It's kind of how much. That's the push and give and take with investors. And the IP lawyers get involved because many times a young company, their valuation is high because it's based on a prediction of growth. But if you're going to grow that big, most investors say, well, I want to see some IP to prevent the question earlier, well, what if Google just likes this idea and wants to run right over us? Well, especially in the US system, if you have enough money for a lawyer, at the end of the day, Google spends $1 million on lawyers, you spend $1 million on lawyers. At the end of the day, there's one lawyer standing up in court talking, and Google has one lawyer. Even if you need a team of lawyers, you don't win lawsuits usually by oh, Google had 50 lawyers and we could only afford 3. There's only so much work, and as the way litigation goes in the U.S., there's a finite number of lawyers that you need on any case. Even the Apple, Samsung case, there were just probably like 8 or 10 lawyers that worked on that. And there were other people that were involved earlier on doing analyses and stuff. Just like when an investment bank does an IPO, there's only so many people that finally sit in the room at the end and price it and do all that work. But the reasons you have IP are primarily defensive, to protect your rights, and they can be somewhat to be on the offense and push competitors out of your space. But you do valuations, like I said, for investing. You often need to do a valuation if you're going to do some kind of licensing or a joint venture. Even as a young company, if you're not going to exit and sell yourself to a big company, you might want to do a partnering with them or do some kind of joint venture with them. And you need to value your company, and a big component of your company value is going to be your value of your IP. Obviously, just like an investment, you need to have a valuation for the company if you're going to sell or merge or be acquired. Sadly, you need a valuation if you go bankrupt or have to liquidate your company if it doesn't make it. Again, at the end of a company's life, the IP assets are usually one of the most valuable because they can usually literally be sold in a box. A bunch of patents, a bunch of trademarks. And it's a way that venture capitalists will get some money back, usually a small fraction, but they'll get some money back. They might have invested $10 million, but they'll get a couple $100,000 at least for some patents and some trademarks. And that's because there's no people left, there's no company left. But it's another reason to at least have had some valuations, because bankruptcy courts can look at previously done valuations and then decide, what's a fair value for the assets. Because those same assets, the landlord to whom you owe rent wants money. The people that sold you the servers that you never paid, they want their money. So everybody wants those last couple assets. So if they're valued correctly, it lets the bankruptcy court actually work out, the bankruptcy better. And then finally, I'm not really capable of talking about this, and probably you don't want to hear about it, but IP valuation is important, especially for public companies and larger companies, in the way you carry it on your balance sheet. And a lot of companies do things with IP where they put them in a holding company and license the IP back to the operating company. And it's for financial and accounting reasons and a way to manage cash flow. But again, people say, oh, why should I spend the money on consultants and on accountants to do this big valuation of my IP? Can't we just, make a guess or just round it up or whatever? And the IP has separate values that need to be able to be taken away from the value that's placed on the rest of the company. So that's kind of there are different reasons, but there's a couple of different reasons people would be motivated to put value on their IP, to put a value on it. And as I said earlier, I sort of started to talk about this. Part of valuation would be driven by an event that usually also is going to accompany what's called due diligence, where people are going to look at your company and put a value on the whole company. Sometimes there simply is an IP, there's valuation of IP, but not typically. The intellectual property assets, it's more and more a deeper analysis than it used to be. Like I said earlier, there has to be an analysis at least of, are the patents and trademarks and copyrights registered and issued? Are they like in good standing? There's fees you pay to keep them alive, like the licensing fees for your car. You actually have to pay these annuities to keep patents in place. So the lawyers and the bankers and the team looks at all that stuff, like are all the right pieces of paperwork in place? Then they look at ownership and say, is all the ownership right? Can we transfer these assets from company A to company B? And then finally, what was usually kind of lacking, you see more and more now, is people look more deeply at the substance. They say, what do these patents cover? you know, how many categories of goods are these trademarks registered in? They don't just say, oh, do you have a patent? Yeah, great. Oh, do you have a trademark? Yeah, great. So the analysis is getting more and more granular, more and more detailed than it had been in the past. And like company valuation, doing evaluation of intellectual property is as much an art as it is mathematics or accounting. And if you ask people, if you ask some of the investors here today, you know, how do you value a company? They'll go like this, you know, like, what does it feel like? But that's because they have so much experience, and it's the same with IP. And it's usually not the lawyers that do valuation in terms of the numbers. The lawyers help the accountants or the consultants that are doing the valuation to have all the facts, to have all the information. What year is this patent going to expire? How many trademarks do they have? What countries do they have trademarks in? So you'll answer all those questions and work with the consultants, but the lawyers themselves don't sit and say, oh yeah, that patent's worth $2 million, but that one's only worth $500,000. That's an economic and a financial analysis that people other than lawyers do, at least in the US. The way in which IP can be valued is very similar to the way almost any asset can be valued. You can value an intellectual property asset using either cost, market, or income. And the cost approach is economic substitution. What would it cost to have a substitute good and in this case, it's complicated because the intellectual property is the good. I'm not talking about the product that the intellectual property protects. That's a different analysis. That's an analysis of the business. But just the IP, you know, you'd have to look at it and say, what would it cost to recreate similar IP? That, in the experience I've had, is usually not a driving factor. That's almost like a floor that people will use as a starting point. You'll say, look, there's this many patents, and they're very dense, hard to create biotech patents. So each one is worth $100 grand because it would cost that much just to come up with some new stuff and then patent it. So if you have the existing patents, you're already $100,000 ahead, and that's like legal fees and the cost of time and opportunity cost. So people will put just a round base number on patent portfolios or trademark portfolios using that cost substitution approach. The second approach people take, and I've seen this with varying degrees of complexity, is to look at the market and say, because this good exists in the market, is there an effect based on the IP that either gives them a higher price or a bigger market share or the whole market share? And then you can back that down in a financial analysis. You build a model, and they'll say, again, separate from the value of the company, they'll say the IP is worth this much. And that will typically, I've seen that mostly in electronics. I have seen it in healthcare a little bit. But to me, maybe because I'm a simplistic engineer that went to law school, I always like the income approach, where people look at the current income. It's the same analysis a little bit like cost, where they separate out what portion of the income could be attributed to the patents, and then they just bring back the net present value of that in the future. If the patent expires in 10 years, you project what your income is going to be for 10 years. You take the IP portion of it, and then you bring it down as a net present value, and that's the valuation today. There's still some subjective kind of tweaking you can do to those models, but it's particularly simplistic because in some industries, there's fairly well-established royalty rates. So you can look at an IP portfolio and say, look, if you fire everybody and go out of business and just have a holding company that licenses these patents, this is how much money you make. So now we can do that analysis and say, okay, then that's what they're worth as a lump sum, and that's the valuation. And then you can add that back into the valuation of the company that the other people have been doing. But otherwise, the main sort of point with valuation is not, like, I'm not here to explain the economics and the systems people use to do valuations, but you will want to do valuation of your intellectual property for very varied reasons. And the most important thing is having all the stuff in place, having all the agreements with employees, having all the assignments, having the IP itself. I mean, that goes without saying, but even the IP itself, having it done right, having all the fees paid. I've had fairly large deals, like 6- and 7-figure deals, that people say, oh, we pay more, but the patent, it expired because you didn't pay this fee last year, and the fee, tragically, is like $180, $180. And this guy lost a couple $100,000, you know. He wasn't a big success, but at least he had a patent, he had a little company kind of going, and he had somebody interested in it. And it wasn't, I was working for the person who would buy it, so it wasn't my fault that it expired, thanks God. But, you know, these things happen, and they happen with really big companies and they happen with small companies. But, because you say, oh, you know, how would somebody not pay that fee? It's your patent. It's like, you know what, it comes up every 7 1/3 years. So I don't know about you, but I don't measure things in 7 1/3 year cycles. I know as an American when April 15th comes, when my taxes are due, you know some other dates, and oh yeah, I gotta pay the bill, you know, on the 1st of the month or whatever. But you really have to be very, very, not you either, your lawyer should do it, but the timing out of these, and there's software that does it for you in bigger firms, it's all taken care of. But if you are working with smaller law firms, they might still do things manually. If somebody messes up even by a few days, the date it's due, and the patent office is brutal about it, if you miss the date, your patent's done, it's gone. Sorry. You know, the plane took off without you on it, and they're not turning around. And that can be a very tragic thing. So in due diligence, you always want to have everything, you have to look at everything, and you hope that you find that everything was done correctly, is what I'm trying to say. That there's nothing missing. Because if it's missing, it gives people huge leverage to negotiate your price down. But as I said, some of the things, if they're missing, it basically would destroy the whole deal. There would be no point to doing it because things are either abandoned or you thought you owned this, but you didn't. So now they have to go negotiate with somebody else. And people just walk away, unless it's such a unique deal or it would delay the deal by like a year. And I guess some people would still do it. But if you had like an ownership problem with a non-employee who was off in the woods somewhere, most people aren't stupid. If you go to them and say, hey, would you sign this assignment that you were supposed to sign 5 years ago? They'll say, well, how much are you going to give me? Oh, nothing, you know, we just forgot to do it. They know. People know what's going on. So they say, well, how about you give me, 10% of the deal or something? And I've done, I won't say for who, but I've done this for like Fortune 50 companies. Gone and found retired engineers in Florida in a trailer park and tried to convince them, how about $5,000, you know? And before the internet, it was a little easier for them to not know that there was some billion-dollar deal flowing through. But big companies make these mistakes too, but for little companies, it's kind of life-threatening, because you can't afford a whole raft of lawyers to try and go fix it. So you want to have it all right. I think that's a universal human trait, though. That's not a Brazilian trait. And you're right. I mean, that's part of the reason I'm here. And it's true not just in Brazil, but in South America and in other regions of the world, too. Brazil's done a really, really good job of stopping just complete piracy. Fake Gucci bags and fake DVDs of movies that just came out last week, copyright pirated stuff. But there's copyright pirated stuff in every big city in the US too. It exists, but we've seen a trend of it coming down in Brazil. People are less likely than they were before to buy pirated goods. And sort of the next step, the next phase of that is to say, not only do you not buy just like pirated stuff off the street, you respect intellectual property in general, in a broader sense. So, but there's plenty of companies in the U.S. that will say the same exact thing. Now, the U.S. has different laws, but it's just like Brazil. It takes years and years and years for litigation. It's very expensive, and your outcomes are not certain. But in the U.S., if you win, especially the patent case, you get triple damages, and that's part of the reason the Apple-Samsung case was $1 billion. It was a $300 million case, tripled, because there were memos from the marketing department that said, I don't care if Apple has patents, forget them. we don't care. Just make the product. We have to compete in the marketplace. We'll deal with it later. When you do that, when you intentionally infringe a patent, when you know it exists and you say, screw it, I'm just going to do it, you get three times triple the damages. So, and a lot of times you get lawyer fees. The Apple case was so big that the lawyer fees are just a rounding error. But I've, again, been in a lot of litigations where the overall litigation was worth a couple $1 million, and the lawyer fees were $2 million. So it almost, again, doubles your award. You get awarded $3 million in monetary damages by the court, and they say, oh yeah, because the other guys were such jerks and intentionally infringed, we're going to make them pay your lawyers. So suddenly it went from a $3 million case to a $5 million case. But this, is hopefully no young company, no entrepreneurial company has to deal with patent litigation, especially patent litigation in the US, that, as you said, we look at it more as you create the IP. The IP is a concrete way to define the ideas that entrepreneurs have, the energy that entrepreneurs have gets sort of written into these documents. And you do that so that the investors can have some security, literally security in the legal sense in what they invest in. And then also people can understand your company as it moves from a couple of really bright people with an idea to a couple of hundred people, and maybe to being part of either a bigger organization or like Facebook or Google growing up into a big giant company. And that's why I like what I've done in my career. Before I came here last year, I represented a lot of venture capital funds, a lot of angel investors, and their startup companies. I have at times in my career quit working in a law firm and went to work for 2 different startup companies. Because I just liked it so much. So I hope that's my message to you, that that the IP, it's a little boring, it's a little complicated. Most patent lawyers and intellectual property lawyers are not that much fun to hang around with, but it's important. It really is.
Is that right? How do we deal with that?
Actually, ANP just issued a few weeks ago. They issued a while ago for public comment their software guidelines. They're moving towards where it used to be you couldn't patent software, you could patent a method of making a machine do something. So you could patent the software that controlled the elevators in this building, like certain kinds of software. You weren't patenting the code, you were patenting like this system. And that's how the US was in the mid-90s. And Brazil's getting a little past that, and I'm not going to stand here and go through I'll be happy to share them with you, but you're right. Like they say you can't patent software, but there are still like clever lawyers that you can patent most kinds of inventions, but it's still not as broadly available as the U.S. Brazil's a little more restrictive in that area. Brazil's a little more restrictive in the life sciences too. They're more restrictive in biotechnology, as many countries are. Many countries flat out won't let you patent a recombinant gene. Not patent. Other countries are like, well, yeah, it's patentable. That's an invention. It's really no different than when people used to take chemicals and mix them and make a new compound. Just because it's a living form, it's made by man, is the line that the U.S. Supreme Court used. They're like, they believe anything's patentable if it's made by man. So a recombinant gene wasn't made by nature or God or whatever you believe in, and that's how the U.S. courts got to like saying, yeah, recombinant technology can be patentable. But other countries, every country has its own sovereign right to decide what's patentable and what's not, what's available as a trade. Well, as a Brazilian company, you're not precluded from filing a U.S. patent, right? So, and that could happen. You're right. If you didn't file and someone came down here and saw your software and your software was less than a year old, somebody could run back to the U.S. This goes on in China to some extent. People file patents for products. So the Chinese file so fast, like they're shown a product as a potential, like to hire them to make it in their factory, and they file a patent on it on the idea that their client brought them. And the Chinese patent office issues it. But in the cases I've heard about, and I only did one, as soon as you show like some emails a few weeks before the patent was filed to the Chinese company, the Chinese patent office like tears up the patent and they fine them, and it's it's a silly system because these Chinese guys do this, and then they try to get you guys to pay them a fee. Oh, you need to buy this patent from me. And they almost make it like they did you a favor. They say, oh, we filed this patent for you. And it's like, oh, come on. You know, you were trying to just do like a stick up. Like the old internet domain name squatting days. That's what that was like. So, and not to say that the Chinese are bad people or anything, but your hypothetical does occur occasionally in China. And theoretically, I've never really heard of it occurring, but you could do it in the US, like you said, kind of see something here that wasn't patented in the US and kind of run back to the US and file a patent. Though, when you sign a patent application in the US, you swear under oath and penalty of imprisonment that it's your invention and you invented it. So again, that's a big risk to take. If you're going to steal, not only do you have the financial and sort of career risk of being known as the person who stole somebody's idea and tried to patent it, in the US you would go to jail. Because you can't file a patent without signing that top cover sheet, and there's a nice printing there, and it has the whole thing, the section of the US code under oath. It's the same as like in the US you've all seen the movies where you swear on the Bible and stuff. It's just like that. So you're making an oath. You're filing that patent under oath. So if you stole it from somebody else, it's perjury. He asked if a patent is personal or judicial? Institutional. It's personal. In the US, and it's different in most other countries. In the US, because the Constitution says patents shall be given to inventors. Inventors were defined as people. So you always have to have the actual inventor, not the president of the company, not the biggest investor, not the chairman of the university department, the inventor. If the inventor is the person who cleans the floors, that's who has to sign the patent. And as I was trying to explain earlier, or talk about earlier, in most companies, in most situations, even in 3-person companies, you have an agreement that says if I invent anything while I work for this company, it's assigned to the company. So the personal right becomes a corporate right pretty much automatically in most businesses. However, in partnerships and in really, really early stage companies, it can be a problem because you'll have a lot of companies where there's the marketing guy and the tech guy. The tech guy actually owns all the patents because they were his ideas, and the marketing guy is doing all the good stuff and making all the business happen and bringing in investors and everything else. And then you get to that table and you say, okay guys, where's your patent assignment? And they look at each other, and then suddenly the tech guy realizes, maybe this isn't a 50-50 deal, maybe it's 60-40, and it's not good. It's not, because now the investor is basically negotiating with a company and the guy individually. So again, who wants to do that? You heard from these investors how many deals they see a day, a week, a month. You don't want to be that company that sits there and says, well, we have to go fight about this for a while, we'll be right back. That's not good. But it's, in other countries, a company can file a patent in the company name from the get-go, so it alleviates this problem. It's pretty unique to the US that it's a personal right. Good, I've exhausted you. Thank you.